There's a few of us out there. There's a Daniel Shemke who's an attorney, and actually you had my wife, Miss Armstrong, in front of you this week through the AG's office. So trying to get
Oh,
everyone I know to go and practice in front of you, Judge.
oh, I didn't know that was okay.
Well, she didn't know if you liked me or not, so I said just keep quiet.
Counsel, of course I do. Look, of course I do. All right. Oops. So we'll see. Oh, Miss Stevenson, I meant to get ready on Shelton, but I'll get ready on Shelton right after this, and then we can kind of muddle through. All right. All right, I'm ready on Perkins. This is case number 224439001. The people of the state of Michigan versus Clarice Leonia Perkins. The defendant is charged with 2 counts of assault or assault and battery. Today is the date set for a pretrial conference. Appearances, please.
Good morning, Your Honor. Christina Ritter on behalf of the people, P number 83505.
Good morning, Your Honor. Christopher Shemke appearing on behalf of Miss Perkins, P74025.
And Ms. Perkins, state your name, please, your full name for me.
Clarice Leona Rebecca Perkins.
Thank you, ma'am. Today, did I say Sharice when I said your name, or did I say Clarice? Oh, okay. Today is a date set for a pretrial conference. Mr. Shimke, how are we proceeding?
Your Honor, we adjourned the matter to get discovery, and it's my understanding that the complaining witness was to be here today. APA Ritter, do we have any complainant here on this matter?
If I may, Your Honor.
You may.
So, Your Honor, this case was arraigned and the court did set it for a pretrial at 8:25, requiring the appearance from the complainant witness. I don't see Ms. Ramona Thomas in the waiting room, Judge, and I don't have an explanation as to why the complainant witness is not present. So at this time, Your Honor, the people will not be able to proceed.
Your Honor,
Today,
at this time.
oh,
Okay.
I'm sorry. No, Mr. Shimke, go ahead, please.
Your Honor, at this time, we respectfully request to have this matter dismissed without prejudice.
Today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear. The people have no explanation for the failure. They are unable to proceed. The court notes that the matter was scheduled at 8:25. It is now 8:55, 8:56. The court is going to grant defense counsel's motion. Mr. Shimke, can you please submit an order of dismissal to my clerk, and then I'll sign it. And Ms. Perkins, he will get a copy to you for your records. Do you have Mr. Flanagan's email address?
Judge, I see that it was put in the chat, so I will make sure that that is done immediately.
All right, and then we're all set then, unless there's something else for the record.
No, thank you, Judge.
Thank you, Judge.
All right, then. Have a great day. Stay safe.
Thank you. Take care. God bless.
All right, thank you. Okay, give me a couple of minutes. I'm gonna get ready on Shelton, but then we can do the couple of other quick ones first. So give me a couple of minutes. Okay, are we ready on? Well, hold on. Let's bring in Buckner. Oh, Buckner. That's the only person. I'll bring in Buckner. And then are we ready on Brown?
Ready on Brown?
And Brown and Pitts, and then Shelton.
Ready on all three of those, Your Honor.
All right. Mr. Buckner, can you start your video, please? Okay. Mr. Buckner, you appear to, well, now he appears frozen. So I don't know how this is going to work out for him. Please let Ms. Roberts know that if he is not she might need to direct him to come in person.
Sorry,
Today, Your Honor.
I was at work.
Yeah, I see you at work, but you have court this morning and you need to make sure that I'm not competing with your job, because I'm not going to, and your signal isn't good. Please accept to join the breakout room. Ms. Stevenson, you too close to your little mouthpiece thing.
My grunting and chewing on my teeth and stuff.
It's something going on. I mean, I wasn't going to say, I just hear some.
No, I want you to, because I'll probably start like grunting in a minute here. I'm having grunting.
Don't do it. Don't do it. This is case number 234551601. The people of the state of Michigan versus Deontay Lamar Brown. The defendant is charged with 1 count of malicious destruction of property, 1 count of malicious destruction of something else. It's cut off on the docket. I don't know why it's not just initials. And today is the date set for pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Stevenson appearing on behalf of Mr. Deontay Brown. Mr. Brown, sir, please unmute and say your full name.
Deontay Brown.
Mr. Brown, can you state your full name for me?
Deontay Lamar Brown.
Thank you. Today is the day set for pretrial conference. Ms. Ritter, what's count 2?
Malicious destruction of a building less than 200, Your Honor.
Thank you. Today's the day set for pretrial conference. How are we proceeding?
On behalf of Mr. Brown, Your Honor, we would move for dismissal for the complainant's failure to appear.
Ms. Ritter?
Judges at least a second scheduling of the pretrial conference, and the court required the complaining witness, Ms. Jessica Kelly, to be present. I don't see the complaining witness in the waiting room, and I don't have an explanation as to why she is not present. So at this time, Your Honor, the people will not be able to proceed.
All right, today is the day set for pretrial conference. The complaining witness was required to appear. They have failed to appear, and the people have no explanation for the failure. They are unable to proceed. The court is going to grant defense counsel's motion. The matter is dismissed without prejudice. Mr. Brown, we will mail you a copy of the order of dismissal for your record, sir. Have a great day and stay safe. Ms. Broden, I need you to get stationary. I need you to realize that you're in court. You seem like you have a lot going on, and I need you to be in court. I need you to be stationary. I need you to be seated in an upright position. ready to attend court. I need you to be stationary, seated in an upright position, ready to attend court. I need you to be stationary, seated in an upright position, ready to attend court. If that is not possible for you, you may have to come in person. Ms. Stevenson, we're going to send Ms. Broden to the breakout room, and Ms. Broden is going to remove her hands from the top of her head because we are in court. We are in court. We are in court. Please accept to join the breakout room and wait for the lawyers to come in to speak with you. Do not leave the breakout room until you have spoken with the lawyer. Ms. Stevenson, the complaining witness is present. So why don't you go ahead and get that person, Ms. Broden, ready, and then I can address Mr. Allen, and then when you come back, I'll be ready for you.
Thank you, Your Honor.
You're welcome. Good morning, Mr. Allen. Good morning, Mr. Allen. Good morning, Mr. Allen.
Good morning, Your Honor.
Can you turn and face me, Mr. Allen? What, are you doing something else?
No, I have the camera on my computer is broke, so I have two screens trying to. Is that better?
I mean, it's not really because you're looking at the other screen. And okay, you're not looking at me. I guess I don't really understand what this.
Oh, I can see you. I'm looking at you.
I know that you can see me, but what I'm saying is you're not looking at me. That's what I'm saying. We're talking, but you're looking over to the side. That's what I'm saying. And you're here on Powell, correct?
That's right.
Okay, well, Mr. Allen, I'm a real stickler for protocol and correctness. So if your screen is broke and that means you have to look over to the side, then we might have to do cases in person. We might have to do cases in person. All right, I'm ready on Powell. This is case number 1-8-445-5901, the people of the state of Michigan versus Sean Lamont Powell. The defendant is charged with one count of operating with a high BAC. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
For the record, Your Honor, Elliot Allen on behalf of.
Counsel, we can't hear you. We can't hear you.
You can't hear me?
Counsel, your appearance, please.
Can you hear me now? Can you hear me now, Judge?
I can hear you a little bit, but this isn't working for me. This isn't working for me.
I don't know what's going on here.
I don't either, but again, I don't either, but it's not working for me. Can you put your appearance on the record, please?
Yes, Elliot Allen on behalf of John Powell.
Okay, whatever two devices that you're on, can they be right together so that when you're looking at the camera, you're looking at me as opposed to me looking at the side of your face?
Is that better? Is that better?
It's a little better. All right, Mr. Powell, your name, please. Unmute yourself, sir.
Sean Lamont Powell.
Thank you. Today is a date set for a final pretrial conference. How are we proceeding?
Your Honor, we have been really slow at trying to get work out with this.
We can't hear you. We can't hear you.
Could you hold on for a second and see if I can get this done?
I'm gonna recall the case. Mr. Powell, I'll put you back in the waiting room. Let your lawyer try to get his devices together.
Okay,
Thank you.
Miss Ritter, do you know someone named Harris that's in the waiting room?
I do not, Your Honor.
Okay, well, it looks like we're ready on Broden. This is case number 23449. 3401, the people of the state of Michigan versus Portia. Middle name is Oreliah, last name Broden. The defendant is charged with 1 count of malicious destruction of property, 1 count of larceny. Today is the date set for a final pretrial conference. Appearances, please.
For the record, Your Honor, Christina Ritter, on behalf of the people, I have the complaining witness present in person. Mr. Mallard, please state your name for the record.
Scott Leonard Mallard.
I don't think we couldn't hear him. What is his name, Ms. Ritter?
Scott Mallard.
I say what, Ms. Ritter, so that the court reporter can have a record. What is his name?
Scott Mallard, Your Honor.
Thank you. Ms. Stevenson.
Thank you, Your Honor. Janice Stevenson appearing on behalf of Ms. Portia Broden. Ms. Broden, ma'am, please unmute and just say your full name.
Portia Aurelia Broden.
Thank you. Today is a date set for a final pretrial conference. How are we proceeding?
Thank you. Ms. Broden will continue her plea of not guilty. We're asking this matter be scheduled for jury trial.
Today is the date set for final pretrial conference. The court is going to continue a not guilty plea on behalf of Ms. Broden and set the matter for jury trial. I believe August the 26th. Well, strike that. Let's go with August the 12th. Mr. Flanagan, is it 3 on there for now?
Yes, Your Honor. Yes.
All right, the court is going to set this matter for August the 12th. At 10:30. Final pretrial conference will be July 2nd at 9:10. The complaining witness has appeared today, and therefore, sir, you are not required to appear on July the 10th. On July the 2nd. However, you may appear if you want to. On July 2nd, we will know if the August the 12th jury trial date is a definite go. If you don't attend on July 2nd, you should contact the Victims Advocate's office or the prosecutor's office to find out if the trial for August the 12th is going. Anything further with respect to this matter?
No, thank you, Judge.
Nothing on behalf of Ms. Broden. Thank you, Your Honor.
Ms. Broden, you're all set. Have a great day and stay safe. Sir, you're all set. Have a great day and stay safe.
You too, Ms. Bryant.
Thank you. Mr. Allen, let's try again. Are you? Oh, well, when did I start recording on the thing? Mr. Allen, can you adjust the camera so that we're not looking completely down your throat? I feel that I'm going to adjourn the case and we're going to come back in person. I don't know. I don't know. Right? I don't know.
Yeah, they're telling me it's taking 2.5 weeks to repair the screen, so we may have to come back in person.
No, now we are going to come back in person. So let's come back next week.
Yes, ma'am.
Help me understand, counsel, why you would get up and walk away from court in the middle of me talking in the middle.
To get the calendar today.
Okay, so in the future, next time you're supposed to say, Your Honor, give me a minute. Your Honor, may I step away for a second?
I'm sorry.
What's the best day for you to come in next week? Not other than Wednesday. I have a heavy docket Wednesday.
Next week is good.
Counsel, you have to talk directly into your device. We cannot hear you.
Next week isn't good for me. I have a medical procedure.
I can't hear you.
Next week isn't any good for me because I have medical procedures that are scheduled for Monday through Friday.
You got a medical procedure every day next week?
Yes.
All right, we're coming Monday, February 5th.
I thank you, Your Honor. I appreciate it.
No problem. Nine o'clock in person. Have a great day. Stay safe.
Thank you. You too. Thank you.
Who did I say I was doing next? I got through off.
Shelton.
Shelton Judge.
What are you doing on Pitts?
I'm moving for dismissal.
Was the complainant required to appear? Okay.
My note says that the prosecution is to confirm their ability to proceed.
Mr. Pitts. Okay, Mr. Pitts isn't ready. And Mr. Pitts is in the dark. Who spoke to Mr. Pitt? He's in the dark. I can't see him. Okay. This is case number 194537901, the People versus Renell Archie Pitts. Defendant is charged with 1 count of malicious destruction of property. Today is the date set for final pretrial conference appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Mr. Renell Pitts. Mr. Pitts, sir, please tell the judge your full name.
Renell Archie Pitts.
Today is the date set for final pretrial conference. How are we proceeding?
Your Honor, Mr. Pitts will continue his plea of not guilty. If the people, I believe, were to determine their ability to proceed today, if they're unable to proceed, we move the matter be dismissed, Your Honor.
Ms. Ritter.
Judge, so the people were to confirm that their witness is still available, which the witness is still available, so we are ready to proceed to a jury trial.
Court is going to continue a not guilty plea on behalf of Mr. Pitts and set the matter for trial. Why didn't I write any information down about Miss Smoot yesterday? All right. Mr. Flanagan, on June 11th, can you tell me when the final pretrial conference is for Sybil Love?
Yes, Your Honor, June 4th at 9:10.
And what about Mingus?
May 30th, 9:10 a.m.
Oh, that doesn't make sense. We need to adjourn Mingus to the 4th because Mingus is the second in priority. So let's adjourn Mingus to June 4th.
Okay.
All right. Court is going to set this matter for a jury trial June 11th. With the final pretrial conference, June 5th. At 9:10. Anything further?
No, thank you, Judge.
Nothing on behalf of Mr. Pitts. Thank you, Your Honor.
Right. Mr. Pitts, in the future, you have to face the sun. You have to face the window. Otherwise, I can't see you. And so you got to face the window if you're going to come on Zoom the next time. All right. We're all set. Have a great day. Stay safe.
Okay, there's literally nowhere else. The TV and stuff
Okay,
right here.
then come in person. That's all I could tell you. I'm not gonna hold court in the dark with you anymore.
Didn't know coming in person was an option.
It's always an option. The court is open.
Not when we started this case, the 6
Okay,
years
but
old.
we're not when we started, sir, and I don't understand why in the world this is any type of back and forth. I simply said you have to face the sun or come in person. Now that you know that coming in person is an option, just choose. But I'm not going to go back and forth with you. Have a great day and stay safe. Miss Walker, they're not here. We'll call you. All right. I'm ready on Shelton. This is case number 23581-8301. The people of the state of Michigan versus London Tayshawn Shelton. Defendant is charged with 1 count of operating while intoxicated. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Janice Stevenson appearing on behalf of Ms. London Shelton.
You might have to go in the courtroom if you go keep on messing with that mic.
For the record, Your Honor, Janice Stevenson appearing on behalf of Ms. London Shelton. Ms. Shelton, ma'am, please unmute and say your full name.
London Shelton.
Your full name.
London Tayshawn Shelton.
Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
None on behalf of the people, Judge.
On behalf of the defense?
Having had the opportunity to review the pre-sentence investigation report, Your Honor, we do, excuse me, Your Honor, find it to be factually correct. And at this time, well, I would just say, Your Honor, on the face sheet in the prior criminal history section, that matter that's listed is still pending. So it's not a prior criminal conviction. And other than that, we have no additions, deletions, or corrections, and Ms. Shelton does stand ready for sentencing.
Anything on behalf of the people?
Nothing on behalf of the people, Judge.
Anything on behalf of the defense?
Your Honor, yes, thank you, Your Honor. With regard to the pending charge that was scheduled for January 23rd, we want to update the court and let the court know that that last hearing was adjourned by the court due to docket congestion. Ms. Shelton is waiting for the next court date. We want the court to know that Ms. Shelton has been had alcohol monitoring, Your Honor. Let's see. For the last several months, as a matter of fact, Your Honor, initially there was she spent 2 months with an alcohol tether, and then she's been submitting to your analysis twice a month since the tether was removed. To my knowledge, there have been no violations. Ms. Shelton is ready to go ahead and take advantage of what we hope would be leniency in the form of probation, which would give her an opportunity to continue to move forward with her life, Your Honor. She looks forward to resolving that matter that's pending over at the circuit court as well. And just will hope that her demonstration of abstinence will have a positive impact on this court.
Would Ms. Shelton like to make a statement on her own behalf?
Ms. Shelton, if you want to say something, you have to unmute.
No, Your Honor.
Nothing?
Just pretty much I learned from this experience a lot. It was basically a mistake that shouldn't have happened. I learned from the decisions that I made. They were poor. And I'm just ready to move on. And at that time of my life, I lost my mother, my brother, same time. It was just a lot going on. So I just want to put this really past me. And I apologize for the actions that came about for my decisions.
All right. I forgot, I did want to make a correction to the report that nobody else made, but on page 4, for some reason unknown to me, there is a whole section filled out with victim statement. And the section starts, the complainant. That's not correct, and nor is it appropriate. There is no victim statement, and there is no complainant. Now, they can label Mr. Dozier as a witness, but unless I missed something, I didn't see where there was any accident in this case.
It wasn't.
No, ma'am, don't, please do that. Ms. Ritter?
Not that I know of, Judge.
Yeah, okay, so then that's the correction. There shouldn't be anything in victim statement, and Mr. Dozier should not be referred to as a complainant. All right. Court has had an opportunity, as I indicated, to review the pre-sentence report. I am ready to impose sentence and do so in the following manner. You know, again, I never get in the business of I shouldn't say I never. It's a rare occasion that I get into the business that is the purview of the prosecutor's office in terms of their ability to make offers, settle cases, and do things and such of that nature. But it's often situations like this when I do take pause and wonder why a particular offer was made. And I know that sometimes there are some things that are standard offers. Like if a person is charged with high BEAC, it's a standard offer perhaps that people will offer operating while intoxicated. But just like there should be some exceptions to every general rule, there should be exceptions to every general rule. And when an individual's blood alcohol is 0.27 and 2.8, I just think it should be an exception. Additionally, when I read the pre-sentence investigation report, it indicated that the police attempted to pull Miss Shelton over, and she took off from the police. And then they had to stalk her street, sit at the corner, and wait for her to come home. And then she tried to hurry up and get in the house so that they couldn't arrest her, I guess, in her house, and they perhaps have to go get a warrant. And those things of that nature. I don't know, but I was very disturbed. I was very disturbed by what I read this morning in the pre-sentence report. Disturbed on several levels. Disturbed by the fact that the police would have to chase after somebody who's drunk. Disturbed by the fact that a person whose blood alcohol is 0.28 would be on the road, putting other people's lives in danger. Disturbed by the fact that the person wasn't too drunk enough where they didn't know that they was trying to sneak back in the house to be undetected by the police. So those things disturb me. And then I don't know what happened to the fleeing and eluding charge, but it it never, I guess, made its way to paper. So the court is going to impose the following sentence. There is a recommendation for probation, and I am going to accept the probation recommendation, but the court is going to increase the term of probation from the recommended 12 months to 15 months. With the following terms and conditions. You shall not violate any criminal law of any governmental unit. You must not leave the state without consent of the court. You must make a truthful report to probation on a monthly basis. And you must notify probation immediately of any change of your address, phone number, or employment status. You must pay the following fines, costs, and fees: $210 mandatory costs, a $100 attorney's fee, a $500 fine, no restitution, $35 per month in supervision fees, for a total of $525, a $100 pre-sentence investigation fee. You shall submit to random urinalysis twice per month at 36th District Court, unless approved otherwise by the supervisor, but I am going to include the urinalysis fees of $300 for the 15 months. The total fines, costs, and fees is $1,735. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any marijuana without a valid medical marijuana card. You shall not use or possess any opiates without a valid prescription and letter of explanation from the doctor. You shall not consume alcohol in any form. You shall not drive without a valid driver's license. Shall attend and complete the alcohol highway safety education level 1. You shall view the victim's impact panel and watch the consequences video. You shall attend outpatient treatment if any positive tests. You shall attend the driver's improvement program, pay any outstanding tickets that you have, or get on an approved payment plan, clear up any warrants that you have, provide proof of your education, or participate in an adult education GED program. You will return to the court for review. Thursday, May the 30th. At 10:00 a.m. Anything further?
No, thank you, Judge.
Nothing on behalf of Michelle. Thank you, Ron.
All right, and we're going to mail a copy of the court's order to the Pennington Street address. Probation will contact you at the phone number ending in 8085. You're all set, ma'am. Have a great day and stay safe. Mr. Flanagan, can you contact Mr. Dillard and ask him if he plans on showing up today?
Yes, ma'am.
All right, I'm ready on Buckner and Reynolds. Any particular order?
Reynolds first, please, Your Honor.
This is case number 20-460-1401, the people of the state of Michigan versus Alexis Diane Reynolds. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for review. Appearances, please.
Janice Stevenson appearing on behalf of Alexis Reynolds. Ms. Reynolds, ma'am, please unmute and say your full name.
Alexis Diane Reynolds.
Today is the date set for review. Ms. Reynolds has completed most of the terms and conditions of her probation. She was placed on a delayed sentence which expires July 22nd. She has a outstanding traffic ticket in a balance of $204. Ms. Stevenson.
Thank you, Your Honor. Ms. Reynolds has advised me she was not aware of that $204 balance. She did check and try to take care of everything by today's court date.
You're
That she
saying
could pay
that Ms. O'Driscoll never told her that she had a ticket. She's been reporting to probation, and Ms. O'Driscoll never said she had the ticket. It just showed up in the report.
Not this ticket. Ms. O'Driscoll did advise her of another matter that she had to take care of, which she did. Today was the first, according to what Ms. Reynolds said to me in the breakout room, today is the first she heard of the $204 ticket.
Well, it's not the first she heard of it, because she heard of it when she was in court and they told her to pay $204.
It actually was, there was a default entered. She never went to court on it because she said she never personally got that ticket. But she could take care of it today, Your Honor.
Okay, well, if she take care of it today, then we will close her out. It's not going to show up today unless she comes down and pays in person. If she comes down and pays in person, she could give Mr. Flanagan the receipt in courtroom 339 and we'll close her out. If not, we'll give her another court date. Anything further?
Ms. Reynolds, did you intend to come down to the courthouse today to take care of that, ma'am?
Yes, ma'am.
Nothing further for the record, Your Honor.
All right then, ma'am, if you pay today, come up to my courtroom 339 after you pay with your receipt. Mr. Flanagan will close you out, okay?
Understood. Thank you, Judge.
All right, you're welcome. Have a great day. Stay safe.
You too. Bye.
Bye-bye. All right, I'm ready on Buckner. This is case number 235714401, the people versus Jeffrey Lindell Buckner. Defendant is charged with 1 count of attempt of police officers assaulting, resisting, obstructing. Today is the date set for review. Appearance, please.
Janice Stevenson appearing on behalf of Mr. Jeffrey Buckner. Mr. Buckner, sir, please tell the judge your full name.
Jeffrey Buckner.
What's your full name, sir?
Jeffrey Liddell Buckner, Jr.
Thank you. Today is the date set for review. Mr. Buckner has this doesn't even look right. I don't even know what this means. Mr. Flanagan, can I see the actual, order from Mr. Buckner?
Yes, Your Honor.
Notwithstanding the order, he has 2 outstanding warrants, Ms. Stevenson.
And Your Honor, Mr. Buckner is asking the court to give him at least another 30 days to take care of the outstanding matter in Harper Woods. He has had some financial issues, which he's been able to rectify, Your Honor, by getting back to work. He just went back to work in December. They were laid off for about 3 weeks because of a company shutdown. Does have 1 child that he's helping to take care of, Your Honor. He is employed, and he's just asking for some more time to make sure that he can get that those other 2 matters resolved.
All right, let me just look at the order. Okay, that must be something I don't remember. Special circumstance that I don't remember. All right. Mr. Flanagan, well, hold on. Let's see. Now, Ms. Stevenson, when you said 30 days, you realize he has 2 warrants.
I do, Your Honor. Mr. Buckner, are you going to be able to take care of both those matters in a month, or honestly, are you asking the court for more time?
Wait, I might not be reading that correctly. Hold on.
Okay, just 1 second, Mr. Buckner.
The warrant. Oh no, maybe. I'm confused. Maybe he only has 1. Maybe he only has 1 at Harper Woods with a $725 bond for the illegal license plate. I read it wrong. Maybe he only has 1. Okay, so it's $725 to clear up the warrant. I don't know how Judge Coleman handles those cases, but your bond is $725, okay?
Okay.
And as long as you don't have the outstanding warrant, it's fine with me. So if you post a bond or if they give you a court date, then the case doesn't have to be at its conclusion, but you can't just have the warrant outstanding. So is
Right.
30 days enough?
Yes, 30 days should be enough.
All right, let's come back February 27th at 10 o'clock. Okay. All right, then you're all set, Mr. Buckner. Have a great day. Stay safe.
You too.
All right, thank you.
All right.
Mr. Harris, can you unmute and tell the court your name? Hey, Sean, can you unmute and tell the court your name?
I'm sorry, I was trying to get this thing to work.
No, just tell me your name. What's your last name?
Tayshawn Baldwin.
All right, Mr. Baldwin, accept to join the breakout room. The lawyer will come in and speak with you in a moment.
Thank you. Yes,
All
ma'am.
right. Mr. Michael Harris, can you unmute? Okay. Mr. Flanagan, did you reach Mr. Dillard?
Your Honor, I reached his office and his assistant was reaching out to him to let him know to log in.
All right.
Good morning, Your Honor. Yes, are you signed into the court?
Why would you be off of mute? This is, you all need, this court. Okay. see if we can get Ms. Jackson connected. I don't know. All right. Ms. Jackson, I'm going to send you to a breakout room, ma'am. Please accept to join the breakout room and wait for the lawyer to come in to speak with you. Good morning, Mr. Dillard.
Good morning, Your Honor.
Are you ready to proceed on the sentencing?
Yes, Your Honor. I believe my client is present in the courtroom as well. We are ready to proceed.
Oh, I meant to look at something first. Give me 1 second.
Mm-hmm.
This is case number 23451-8901, the people of the state of Michigan versus Curtis Foster Petway. Defendant is charged with 1 count of guns, reckless use. Today is the date set for sentencing. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
Joseph Dillard, P37225, on behalf of Mr. Curtis Foster Petway. Mr. Foster Petway, please state your name, your full name for the record.
Curtis Foster Petway.
Thank you. Today is the date set for sentencing. The court has had an opportunity to review the pre-sentence report. With respect to the report itself, are there any additions, deletions, or corrections on behalf of the people?
None on behalf of the people, Judge.
On behalf of the defense?
None, Your Honor.
With respect to sentencing, is there anything on behalf of the people? Was I supposed to come in person today?
No, this is on Zoom.
No, I'm not talking to you, Mr. Dillard. Mr. Flanagan, was I supposed to come in person today?
I think it's set for in person.
Oh, it's not at an in-person time. It's set at a regular time. In-person time would have been 10:02. And the defendant is not in person either.
Yes, Your Honor. On November 30th, Judge Austin Garrett set it for a restitution hearing today at 10 a.m.
Yeah, but you said it's virtual?
Yes.
That's for Ms. Jackson, correct?
Yes.
Okay. I think the prosecutor thought it was in person because he's in person and his witness is in person. Okay, I'll get back to that. All right. I apologize, Mr. Foster Petway. Okay, so, with respect to sentencing, I'm sorry, Ms. Ritter, was there anything on behalf of the people?
Nothing on behalf of the people, Judge.
All right, with respect to sentencing, anything on behalf of the defense?
Your Honor, just asking that the court honor the sentence recommendation, term of probation, handgun safety intervention classes, no possession of any weapon during the probation term with consent to HIDA, and ask that this court proceed on with the HIDA probation.
But you said two things, and one of them is not correct. And I suppose you're saying you want me to accept the people, the plea agreement that says consent to HIDA, because probation recommended no HIDA.
Your Honor, again, in this particular case, I believe that HIDA is appropriate. When you consider the wisdom of the legislature, they even amended the ages to go up to the age of 25, where the brain development is a little delayed. In addition, HIDA is available even if somebody has taken advantage of HIDA at a prior time. I believe that HIDA is very warranted. It's appropriate. In this particular case, I would ask that the court consider the judicial wisdom that allows multiple uses of HIDA, and as well as the court interpretation of HIDA applications. This is a misdemeanor charge, and far more serious charges receive HIDA on multiple occasions. And you're looking at the rehabilitation and training of an individual during a period without the necessity of maintaining a criminal record. My client, in this particular case, my client did have a CPL. And so he's been compliant to an extent with the law of the state. That being said, nevertheless, it is discretionary with the court. It's a recommendation from the prosecuting attorney's office, which is rare. It is not a commonality where everything, once they get past 20 into 21 plus, through the age of 25, or 20 goes up to 26. With 26, it terminates. But through the age of 25, and the prosecuting attorney's office, which handles multiple cases, felonies, and everything else, I think they have the executive branch of government, the wisdom that comes from their unique experiences as well. I'm asking that he be appointed or to the HIDA probation status as recommended by the executive branch, the prosecuting attorney's office, recognizing that it is up to this honorable court in terms of the recommendation. That recommendation is rare. It is given, and I believe that it's appropriate.
All right, would your client like to make a statement on his own behalf?
Mr. Foster Petway, do you wish to make any statements?
No, thank you.
All right. And the court has had an opportunity to review the report, as I indicated. And the people did consent to HIDA. The probation department did not recommend HIDA. And the court does observe that Mr. Foster Petway has had the benefit, has had a previous benefit of HIDA, notwithstanding. So I'm going to just address a couple of things. I believe, of course, in the separation of powers. Absolutely. Just like I know that outside of of setting the parameters of the law, the legislative branch can't tell me what to do. In terms of that, they set the law, and then I enforce the law in the way that I read the law, and then, Supreme Court and things and such, they can tell me if I've interpreted it wrong or if they disagree with my interpretation, I should say. And I do believe in, of course, giving people another chance and another chance and another chance. I don't know that it's the wisdom of the legislature, though, that changed that HIDA statute, because it could just also enable an individual to continue to, commit crime and then get the benefit of HIDA without it affecting them. Also, when I look at some of the things that the legislature does in terms of setting domestic violence cases at a 93-day misdemeanor, setting assault and battery cases at a 93-day misdemeanor, and then setting gambling at a 1-year misdemeanor, that doesn't sound so wise to me. So the legislature has flaws that they do need to correct. As it relates to Mr. Foster Petway, Mr. Foster Petway, it appears in this instance, because I did read the report and it said he did have a CPL, so we're good with that. And so he, of course, wasn't charged with anything like not legally possessing the gun. But one of the things that goes with having a CPL is responsibility. It's responsibility and knowing when to use your weapon and when not to use your weapon, when to pull your weapon, when not to pull your weapon. So having said all that, Mr. Foster Petway, you are at the end of being eligible for HIDA. You're at the end of it. You're at the end of being able to take advantage of the fact that certain things won't appear on your record. And so you have to be a little bit more responsible, because I didn't like what I saw. Now, I do know that he had, it seems like this was all one case, though, the way I'm reading it. So he just had the one case, and then count 1 was dismissed, and then count 2 was deferred. That's how I think I'm reading it. So nonetheless, I am going to accept and honor the recommendation for HIDA. So after today, your case will be suppressed, Mr. Foster Petway. I will honor that, and then it'll no longer appear on your record after today's sentencing. Mr. Flanagan is going to make the case private after today, and then you will, well, I guess I should say, because the people are still consenting to HIDA, notwithstanding the probation department didn't give a reason either, but it says eligible, but not recommended. They didn't give a reason, so I don't know why they said that. But the people are still consenting to HIDA as it relates to Mr. Foster Petway, correct?
That's correct, Judge.
All right, the court sentences Mr. Foster Petway to the term of probation for 18 months. Of course, you will be eligible for early discharge after 9 months, and the court sentences you under the HIDA statute. And so, as I said, this is your last go at it with HIDA, so make sure that you're responsible in your future dealings, Mr. Foster Petway. The court is going to set a final probation review date for 12, 13, 14, 15, 16, 17, 18. So if we get to the 18 months, the final review date will be set for July the 20, what's today? 6, that's a weekend. So July the 25th, let's put it on July 24th. July 24th, 2025. And then I'm going to give you another review date. At the first review date, you won't be eligible for discharge. You'll be eligible for discharge after 9 months, but I'm going to give you a 5-month review date to see where you are and see how it's going. So 1, 2, 3, 4, 5. We're going to come June the 20th. Let me make sure that's a good day for me. Oh, it might not be. Oh, yes, it is. June 20th at 1:30. That's your first review date. It is on Zoom. The terms of your probation are as follows, sir. You must not leave the state of Michigan without consent of the court. You must report to probation on a monthly basis. You must notify probation immediately of any change of your address, phone number, or employment status. You will pay the following fines, costs, and fees: $210 mandatory costs. Mr. Dillard, were you appointed or?
Retained, Your Honor.
Okay, thank you. So no attorney's fee. You will pay a $400 fine, no restitution, oversight fees for the 18 months at a rate of $35 per month is $630. If you are discharged at the halfway point of the six, you would only have to pay half of the $630. So you would have to pay $315 of the supervision fees if discharged at the halfway point. The court is going to impose a $50 pre-sentence investigation fee. And let me look at your drug test. I'm sorry. Okay, I am going to order at least one additional drug test during the course of your probation. But I'm not ordering random testing. So no random testing, but one additional test before discharge. All right. And I want it closer to the halfway point. So maybe I'll say, well, I'm not going to say that. I'll leave it up to probation. They can test you whenever they deem it necessary. So the total fines, costs, and fees are $1,290. Of that, oh no, I'm sorry. I'm going to add $10 for the one test. So that's $1,300. Of the $1,300, in order to be discharged early at the halfway point, you would have had to pay $985. Additionally, you shall not use or possess any illegal substances. You shall not use or possess any opiates without a valid prescription and a letter of explanation. You shall not drive without a valid driver's license. You shall not, Ms. Ritter, he had a valid CPL with respect to this case. Is there any restriction on his firearm? Now, if he was convicted of reckless use of a firearm, what does that do to his CPL?
Judge, so I'm sorry.
No, go ahead.
No, I was gonna say, Judge, from my understanding, this is not the penalty where it's a mandatory weapon forfeiture as for prohibition, but the people just recommended no possession of a weapon during the probationary.
Oh, you did. I see it, and I apologize. I did. You did. Okay. So you shall not use or possess any firearms. So listen, Mr. Foster Petway, that means notwithstanding whatever your CPL status is, you need to put that gun in a lock and a lock case, and let somebody hold it for you. Somebody else with a CPL, or just keep it in a safe or something. You can't be found with it while you're on probation. And then you shall, all right, let's see. You shall attend the handgun intervention program and choices. as well as aggressive self-realization. I'm going to say if Mr. Rice deems necessary. So with respect to the aggressive self-realization, I'm going to leave that up to Mr. Rice. If he does choices, then Mr. Rice will determine if he needs aggressive self-realization. He may not. So I'll leave that up to Mr. Rice. You will pay all outstanding tickets that you have. According to the report, it says you have a zero balance. And then if you have any warrants, you have to clear them up. But according to the report, you don't have any. Let me see. Of course, as I indicated, I'm not ordering the random urinalysis, and I'm definitely not ordering outpatient treatment. I didn't see any need for that. Oh, I apologize. I completely skipped over. There's a recommendation for anger management. So you're going to also do 12 weeks of anger management. Is there anything else for the record? Why are you laughing, Mr. Foster Petway? What's funny?
It was the anger management. It was the anger management. I might need a little therapy. I don't know about anger management though.
Oh, trust me, Mr. Rice will get you together, whichever one you need. You probably do need anger management.
I'm a very happy person. I ain't angry.
That don't mean nothing just because you're a happy person. Happiness is fleeting. It's determined by the situation at the moment. I forget I'm at work. I can't start. I was gonna say it's that joy that I was getting ready to go into a whole nother part, I think. Well, what I'm gonna say is Mr. Rice is I always have to tell people I don't know Mr. Rice. I've never met the man in person. What I'm saying is what I've heard about him from the defendants. So this is information I get from the defendants that I send him, that he's phenomenal. And so if you think you need counseling and not anger management, say that to Mr. Rice and see what he says. Let him talk to you. What I'm telling you is I trust Mr. Rice, having never met him. I trust his judgment. He has done some phenomenal work with people that come to my courtroom. If he tells me that you don't need anger management, I promise you, I won't even. I think did the prosecutor say you had to do it? Oh, no, they didn't. Okay, so let me tell you what I'm gonna say about the anger management. I'll say the same thing for the anger management that I'm saying for the aggressive self-realization. If Mr. Rice says you don't need it, you don't have to do it. So he'll send me something back if Rice says need it. If Mr. Rice says you don't need anger management or the aggressive self-realization, I'll remove it from the order. But I want you to do the choices program, okay? All right.
Okay.
All right. Anything further with respect to Mr. Foster Petway? Because he said he don't need anger management. I need anger management, Mr. Foster Petway. But I can't go up there with the defendant, so I'm gonna have to get my own private class.
You seem like a great judge. I don't think you need it.
Oh, you ain't see. Some days I do need it. Some days I need it. I won't even lie to you. Some days I need it. All right. Anything further with respect to Mr. Foster Petway on behalf of the people?
No, thank you, Your Honor.
On behalf of the defense.
One thing, Your Honor, at this time, may I be discharged?
Yes. The misdemeanor felony defender's office will take over. But I have a feeling that we won't need. I have a feeling Mr. Foster Petway is going to knock it out the ballpark.
Thank you. Thank you.
All right. And maybe you could go over there and help Mr. Rice with his program, because I keep telling Mr. Rice, I keep sending messages to him say he needs somebody that he's going to train to take over for him, because I don't know what I'm going to do when Mr. Rice doesn't do this anymore. I was trying to see what you do for a living on there. I didn't remember. Hold on. Look, if it's got anything to do with oh no, it don't have nothing to do with that. But that don't mean nothing. Look, you might be the next Mr. Rice since you're so happy and stuff.
I hope so.
All right. Well, then we're going to mail a copy of the court's order to your Moraine Street address or Meringue Avenue address, and then probation will call you at the phone number ending in 1467. We're all set. Everyone have a great day. Stay safe.
Thank you, Anna. Have a wonderful day as well.
All right, you're welcome. Thank you. Whoops.
And also, Yana, if I can be sent a copy of the court order as well.
Mr. Flanagan, email him once we sending it to Mr. Foster Petway.
Okay.
All right.
Thank you.
All right. You're welcome. Oh, I forgot he was even there. Why is he still there? Oh, I guess I need to bring in the iPhone before I tell him that. Hold on. Let me bring in the iPhone first. Hold tight, Mr. Ogletree. All right, can the person on the iPhone please tell me your name?
Good morning, Judge Tasha Bass Sylvester.
All right. Start your video for me.
Okay.
Miss Sylvester, good morning. Do you know if is Miss Burton still going to represent you through the probation, or is her representation concluded?
I believe her representation is concluded.
I think so too.
Okay.
So I'm going to send you to a breakout room, Ms. Stevenson. I'll send you Miss Sylvester's update.
Okay.
Thank you, Your Honor.
You're welcome. All right, I'm going to take a short break, about 5 minutes, and then we can finish the docket.
May I ask a quick question, please, Your Honor? Mr. Norris just texted me. He is still in the middle of a high school equivalency exam right now.
Well, why is he texting? That's cheating, ain't it?
No, he called me, so I don't know, but
hold on, that's not what I'm trying to do. And I'm sorry, who is that?
That's Tremont Norris, Your Honor.
Oh yeah, okay. And what does he want?
Just another day so he can
we can
finish
address
that test. Okay, thank you, Your Honor.
I feel like that would have all right. That would have made me. Counsel, you are all set. The defendant never showed up.
I can leave, Your Honor?
Yes, sir.
All right, thank you. Take care.
You too. Mm, mm.
I'm here, Judge, just so you know. I'm back from break.
Okay, well, I wonder if the other people are here. That's what I want to know. I'm ready. Let's go with Baldwin and then Sylvester and then Jackson. Oh, Miss Ritter, it looks like you're done. Miss Ritter, are you there?
I'm here, Judge.
All right, looks like you're done.
Okay, thank you, Judge. Everybody have a good weekend.
All right, you too. This is case number 216257701. The People versus Tayshawn Baldwin. Defendant is charged with 1 count of guns, reckless use. Today is the date set for review. Appearance, please.
For the record, Your Honor, Janice Stevenson, appearing on behalf of Mr. Tayshawn Baldwin. Mr. Baldwin, sir, please unmute and say your full name.
Tayshawn Baldwin.
Thank you, sir. Today is the date set for review. Mr. Baldwin was placed on probation. Well, there's some confusion. Well, it's no confusion. I mean, I don't know. There's a discrepancy in the ROA and in the order that the court signed. So I guess we're gonna have to, the order would prevail, but I don't know what it was supposed to be. Mr. Baldwin has completed most of his terms and conditions. He still has 2 to complete. And he was placed on probation, it looks like in September. Ms. Stevenson.
So we're going to ask, thank you very much, Your Honor, that the probation continue to give Mr. Baldwin an opportunity to come fully into compliance. We believe he is making some headway. He is working. He can make payments toward his costs and fines, Your Honor. He knows that he needs to go ahead and make sure that those warrants are cleared up so that he can go ahead and lead a prosperous life. And I think Mr. Baldwin comes to court like he's supposed to. And I'd ask that the probation continue to give him an opportunity to fully comply.
To the final review date, well, to the review date of September the 22nd?
Yes, please, Your Honor.
All right, well, we will continue to September 22nd, 10 o'clock. All right, anything further?
Nothing on behalf of Mr. Baldwin. Thank you, Your Honor.
All right, great job, Mr. Baldwin, so far. Keep up the good work, and I'll see you in September.
Okay, thank you.
You're welcome. All right, I'm ready on Sylvester. This is case number 214435301. The People of the State of Michigan versus Taisha Shabazz Sylvester. The defendant is charged with operating while visibly impaired. Today is the day set for review. Ms. Stevenson.
Janice Stevenson on behalf of Taisha Shabazz Sylvester. Ms. Sylvester, ma'am, please say your full name.
Good morning, Taisha Shabazz Sylvester.
All right, today is the day set for review. Ms. Sylvester is doing a great job so far. She does have a substantial balance, and she was scheduled to, I had placed her on probation for only 9 months, with her final review date being in May, but she still owes $1,200. So, Ms. Stevenson.
Which she can pay by the end of February, Your Honor. She said she did already watch the consequences video about 5 days ago.
Okay. So, I don't know how they ask for proof of the consequences video. But you need to get that proof to Ms. O'Driscoll. Tell me something that happened on the consequences video.
Good morning, Judge. Just a few things that happened on the consequence video. The victim was was on the Oprah Winfrey Show telling her life story about how her life had changed, and how it was impacted by a drunk driver. Her name was Jackie Subarito. I believe I'm pronouncing her name right. She was a college student going to school for engineering. She wanted children. Two of her friends died in a car accident. Her life was greatly impacted by the drunk driver. He went to jail for several years. He was released in 2008. I did do.
I believe you. What did you learn from it?
You know what? Making the wrong decisions, not only can you affect your own life, but you affect others' lives. And she was a beautiful young woman, and just making the wrong decisions and had a huge impact on her life, her career, and so did it for the young man. And even though you don't mean to make those decisions, your poor decisions in drinking or doing drugs, it leads you down the wrong path. It's not worth it. Not worth it.
It's and sometimes, you know, the people who survived the accident. I mean, once you're dead, you know, nobody wants their life cut off short. But you know, a person that's getting tortured, they prefer death. A lot of times, a person that's getting tortured, they'll say they prefer death. And people who survive accidents, who are now, you know, their whole lives have changed. They could be quadriplegics, paraplegics, you know, they could have to rely on people to, you know, do things for them. They could, I mean, when my sister was living, there was a young man in the nursing home with her who had gotten paralyzed from the neck down and didn't have family to take care of him. So he ended up in a nursing home because of a drunk driver. And so that, you know, I just want people to just be more thoughtful in their choices. People can be self-destructive. We don't want them to do that either, but you know, people have to stay home, take a Uber, take a Lyft, take a taxi, take a, you know, those type. Those type of things. So anyway, I believe you watched it. I'm gonna check it off. But so you still have a balance. When do we want to come back then?
I can have you want, am I speaking, Judge?
Sure.
I would ask to speak, yes.
Go ahead.
Yes, ma'am. I can pay it off by the end of February.
So then we want a March date then?
Yes, ma'am.
Let's come back March the 14th at 1:30. All right, but great job so far. Yeah.
Thank you, Judge.
All right, you're welcome. Then we're all set, ma'am. Have a great day. Stay safe.
Thank you, Your Honor.
All right. Okay, I mean, I guess I'm ready on Jackson, but I'm a little, I don't know. So, well, Miss Jackson is not in person. I'm not in person. And I'm assuming, is there a dispute over the restitution, or have you all agreed and consented?
Good morning. I don't believe that there is an agreement with regard to the amount of restitution.
Okay. And then, so now so logistically speaking, I feel like we have a problem. How do you all propose that we do the hearing today? I mean, I suppose, is there a lot of documents?
There are, Your Honor.
Ms. Stevenson, where does your client live? How far, how far does your client live?
I'm not sure that she's at home right now. She lives in the city, Your Honor.
Okay, well, I think that me and your client are going to have to make our way downtown in order to have the hearing. Because how am I going to see the documents, and how am I going to, how is your client going to see the documents? How are we going to, I don't think we could proceed without us being in person if 3 people are in person.
I mean, I know even if we are in person, Your Honor, the documents are voluminous.
So you're saying you're not ready to proceed today anyway? You haven't
No,
had
I'm ready to proceed.
okay, right. So if we're in person, who cares if the documents are voluminous? I have to
So
be
no,
able
that's
to
what I was saying, that we're gonna have to use technology anyway if Ms. Jackson wants to if she wants to look through anything. So I can always, which I really don't even think I need to do that, Judge.
Okay, I don't understand what you're saying. I'm gonna have to receive these exhibits. They're not electronic, are they?
I do have them in electronic format, but I intended to introduce them, the paper copies.
Yes,
We
and
can
then
do that at the pleasure of the court.
okay, and then also, where's my what was the original chart? Oh, here's my docket. Okay. Oh no, that's not my docket. I'm sorry. I keep putting stuff down and can't find it. I haven't moved out of this spot. What's the charge? What's Miss Jackson's charge?
She was charged with assault or assault battery.
Well, I can't imagine the documents are that voluminous. She wasn't charged with aggravated assault. What
Yes, Your Honor, may I make a proffer?
You may, yes.
Your Honor, I have what I would say are 3 sets of records. One is from the immediate urgent care. And so that amount. Then there is treatment that Ms. Drakeford sought for her head and face 2 days after that. And then the third set of records are records that Ms. Drakeford says are from her pain management and surgeries on her back related to the fall that she took during the incident. And so that is that third set of documents are the bulk of the records and the bulk of the financial restitution that Ms. Drakeford is seeking.
Okay, this is what we're going to do. We're in recess, and myself and Miss Jackson has to come downtown. We're gonna start up at 11:30.
Do you need me to come downtown, Judge?
If you can't hear us clearly, so you might. I mean, well, probably.
Okay. Your Honor, could Ms. Jackson and I go into a breakout room? I just want to see exactly where she is and all that.
Okay, well,
in case I need to ask for a little bit more time.
Oh, okay, because exactly this is going down today.
Yes.
Okay. Okay,
I'll pack up and head down.
Okay. Hold on. Okay.
Thank you, Judge.
You're welcome. And then Mr. Henderson, when the court reporter gets down there, as much as possible, have you already marked the documents or you haven't?
I haven't, Your Honor.
So when the court reporter gets downtown, just organize them as such so you can maybe get them pre-marked with her.
Yes, Your Honor.
Okay.
Okay, I'll make sure I have a lot of stickers.
Okay. All right. So you can go ahead and come head down, Courtney, I guess. Well, let's see if it's gonna be at, I don't want to do it at 1:30, but I don't know where Miss
I'll wait and see what time. I'll be sitting here packing up.
Okay. I guess it's a good thing that I'm in the state. Look, you kept asking me about something and it didn't never click. That I'm 10:02. Everything in person is 02. Okay. All right. Let's see what time. Let's see how much time. No, it's not going to be before 11:30 because it takes me at least 20 minutes to get downtown, so it's not gonna be before 11:30. And let's see how long Miss Stevenson is gonna take finding out what time. Let's see how long she's gonna take to find out. And we're gonna come. Okay, Miss Stevenson.
I'm gonna need a little bit more than 30 minutes. Ms. Jackson would have to take a bus, which might take her over an hour, so I'm gonna go get her.
No.
So I'll go pick her up, but I need more time than 30 minutes.
I mean, too bad I can't pick her up. Miss Stevenson, I didn't want to do. I mean, when you say you need more than 30 minutes, then how much time you need?
Because it's showing
I said how much.
Oh, okay. I would say maybe an hour, maybe by the time I get downstairs, get to her, get back.
So
maybe 45 minutes if.
Okay. All right. Well, then let's go.
All right. Okay. Thank you, Your Honor.
Okay. So we're on our way. And thank you both for your patience. And then I'm assuming that Ms. Drakeford is the only witness that you have?
Yes, Your Honor.
Okay, so you all are on recess till we're on our way. We're getting ready to come down and Ms. Stevenson has to go pick up her client. So
yes, sir.
Be patient with us. Okay, here we come.